Welcome all to this webinar on the WOA. My name is Robin de Wit and I'm here together with my colleague Mike Correa. We're both lawyers in the restructuring and insolvency department of HVG Law. Today we will bring to you the highlights of the WOA, or on a different name, the Dutch scheme. This new legislation was introduced 3 years ago and could prevent bankruptcies of companies in financial distress. On the other hand, it could force creditors and lenders to write off part of their claim. So this webinar is not only relevant for companies in financial distress, it is also relevant for basically any company that does business, as all could receive a WOA restructuring plan with a request to vote. In this webinar, we will discuss the basics and how the WOA works in practice. Yeah, the subject is also on the news. Wakker Mama, Big Bizarre, Vroom, IAC, McDermott, Steinhoff, Vitesse, ADO Den Haag, Shubi are all companies that have initiated WOA proceedings or at least tried to do so. These cases have all been publicly discussed, but there are many more cases for large and smaller companies where out-of-court restructurings were agreed upon and whereby the WOA legislation serves as a way to force creditors to cooperate. Now that we have this WOA legislation that could force creditors to a settlement proposal, we see in practice that more companies agree to a certain settlement voluntarily if a company is in financial distress. And that has always been also one of the objectives of the WOA. Which works in practice.
Robin, thank you for the introduction. So basically, a WOA is agreed upon a settlement with creditors. Before the WOA legislation came into force, it was very hard and difficult to reach a settlement with all creditors. If one creditor opposed, it could basically block a creditor's composition, which often led to bankruptcy of the company involved. With the WOA, even opposing creditors can be forced to cooperate with the creditor's composition offered, aiming to reduce the number of bankruptcies of companies that do have a viable business but threaten to become insolvent due to the over-indebtedness. The first purpose of the WOA mentioned on the slide has already been discussed by Robin. The second one, the controlled liquidation, is also important. If a business is not viable and wishes to cease its activities, it's basically forced to apply for. It was basically forced to apply for bankruptcy in cases of over-indebtedness. The WOA could help to lower the outstanding debt to bring it in line with the assets. Value of the remaining assets so that the bankruptcy can be avoided. The WOA is basically the Dutch equivalent of the US Chapter 11 proceeding and the UK scheme of arrangement. Also in the WOA, the debtor remains in charge and fully entitled to carry on the business operation. There's no trustee appointed. Furthermore, the WOA takes an economic approach. An important question is, does a claim on a company has any value in bankruptcy or in a situation whether the company is restructured? For that value, there is an economic interest and that amount needs to be received by the creditors. But for the remaining, a creditor can be forced to write off part of its claims, even if it does not approve with the proposal.
Right. When can a company apply for a WOA proceeding? Well, the criteria is if it's reasonably likely that the enterprise will be in a position that they are unable to pay their due and payable debts. That is now and in the future. And yeah, it could also be 9 months before a company runs out of money. And it is necessary to start a WOA timely, as it is mandatory to pay ongoing obligations during the WOA process. In practice, a reference date is set and the debts outstanding at the moment of that reference date will be part of the WOA scheme arrangements. and all obligations that arise thereafter need to be paid. Well, in practice, a WOA proceeding could take 4 to 8 months, so you really need to have liquidity to cover that whole period to pay the ongoing obligations. What needs to be in a restructuring plan? Well, the restructuring plan basically describes the situation the company is in, what is done to restructure the business, not only financially, but also operationally, because you need to explain how the company is going to overcome the financial difficulties, and why the company cannot pay the creditors in full. Basically, it explains to the creditors that if they do not cooperate with the restructuring plan, the company will go bankrupt and they will receive amount X, while if they cooperate with the restructuring plan and accept the offer made to them, they will receive more, being I. Well, how is it now being determined what needs to be offered to the creditors? Well, there is flexibility on that, but the basic is that the value of the company is being divided among the creditors in accordance with the rights these creditors have in a bankruptcy situation. So for this evaluation of the company, determining the value of the company as if it has been restructured needs to be made, and that is called the restructuring value. And that restructuring value is being, divided among the creditors. Well, how is that dividing the value being done? That is done in accordance with the priority rule. That means that creditors with a high rank in a bankruptcy situation receive more than ordinary creditors. Creditors with security rights and creditors like the tax authorities who have a preferential claim receive more than ordinary creditors. And in order to divide the value of the company in accordance with that priority rule, the creditors need to be put into classes in accordance with their rank. So you have, for instance, a high-ranking class with the security right holders, a lower rank with the tax authorities as preferential creditors, and a other class of creditors with the ordinary creditors in there. And then you have basically 3 classes, but in practice many more classes are possible if you have more creditors with different ranks. Another basic rule is that the creditors always need to receive more than they would in a bankruptcy situation. This is the creditor's best interest test. And in order to demonstrate towards the creditors that they receive more than what they would have get in a bankruptcy situation, a liquidation value needs to be determined, and for that usually a liquidation value report is being made. Well, in order to protect the creditors' rights and to make sure the creditors can check that they get what they are entitled to, the creditors need to receive quite a lot of financial information. They need to get, just financial information, past, current, and future financial information, substantiation of the liquidation value and the restructuring value and how it's being calculated. And of course, they also need to have information on the clauses and the reasoning behind the clauses, how it has been put together. Sharing the right information with creditors is important, as it could block approval by the court if not all the information is being provided. Well, when the restructuring plan is finalized, it is being sent over to all creditors whose rights are being affected and then put up for a vote. And all creditors whose rights are being affected by the restructuring plan have the right to vote on the plan and let the company basically know if they accept the offer or not.
So, how does the voting mechanism work? Anyone affected by the scheme can vote. the company determines how that vote can take place. It is common now that online software is used to provide all the necessary information to the creditors, and the creditors could also let the debtor know, the company know, by the online tool whether they agree or not with the proposal. In order to submit a WOA restructuring plan to the court for approval, only one class must have agreed to the plan. But of course, that class must be a class what we call in the money in case of the bankruptcy. The other descending classes can still be bound by the plan if the judge approves the restructuring plan. This is a so-called cross-class cram-down. Of course, it's easier if there's a lot of support from the WOA restructuring plan. How is it determined whether a class is for or against the proposal? For this, within a class, 2/3 of the value of the claims of creditors who have voted need to vote in favor. The entire WOA procedure can be completed very quickly, but like Robin said, in practice it takes a few months, but it could be done within 2 weeks, of 12 weeks. It's also important that no appeal is possible if the court approves or rejects the agreement. This increases the deal certainty. If all creditors agree, there's no need to ask the court to approve the restructuring plan. The out-of-court agreement can then be executed in accordance with the plan, and all creditors are bound due to their agreement. If not all creditors agree, the court can be asked to approve the plan, and if approved, also the dissenting creditors are bound to the plan. It's also the case that once a WOA homologation has been rejected, the debtor may not make a WOA request for 3 years. This should prevent the company from betting on the lowest possible distribution to creditors. In case of rejection, there's no second chance. It must be done correctly in one go, and therefore with a reasonable proposal in accordance with the legal requirements. And what you see is on the slide a schematic overview of the proceeding. Basically, this information already is told by Robin by his last slide. So you have 4 main actions: the preparation, proposal to the creditors and shareholders, the voting by the classes, and the court hearing. And what we did not mention in the conversation with is the conversation with the stakeholders. Of course, it's important to obtain the support from the important financiers, suppliers, and possible other parties. In order to get the support, it's important to take them along during the preparation of the restructuring plan. Before preparing the restructuring plan to all the creditors, you need to know if you can count on the support of the parties you need the support of. After submitting the proposal to the creditors for formal voting, it's important that the voting period is sufficient, and as there may be time needed to get the supporting vote of the tax authorities as an important preferential creditor, and to provide some further explanations to the creditors.
Okay, how does the creditor protection work, and what are the grounds for refusal? Well, court refuse to approve a WOA scheme on various grounds, and these are listed on the slide. First of all necessary information needs to be submitted to the creditors, and the formal requirements need to be taken care of. Of course, the company must also be in the situation that it is actually in financial distress. And it must also be certain that the proposals made to the creditors can indeed be met. So if you offer 20%, you need to make sure you can actually pay that 20%, and that's the feasibility test. The class formation should be in order, the creditor's best interest test, priority rules should also be adhered to. And to grant the court's flexibility to refuse approval on other reasons, well, also the other reasons as kind of catch-all are also included in the law. If creditors want to oppose against a WOA proposal offered, it is important that they do so as soon as they are aware that any of these refusal grounds are applicable. Creditors should not wait with filing their objections until the court hearing, because then the court could judge these objections as being too late. In practice, this is also called you snooze, you lose. So if creditors have any objections against the proposal, the procedure, the class formation, or the valuations made, they must present their objections as soon as possible so the debtor is able to take this into consideration and, if necessary, amend its WOA proposal. What we did not yet mention are the roles of, well, two persons in a WOA process, and it could be the observer or the restructuring expert. These persons can be appointed by the court, but only in certain situations. So these persons are not appointed in every WOA proceeding. Well, an observer is an independent person, usually a person who also takes appointments as a bankruptcy trustee. And that person is appointed by the court to oversee the WOA process. And the duty is to make sure that the creditor's rights are not harmed during the WOA process. An observer is usually appointed if there are opposing creditors, objections against the restructuring plan, or if a cooling off period is ordered. A restructuring expert can also be appointed, and that will be at the request of the debtor itself or a creditor or a group of creditors. And the duty of the restructuring expert is to prepare the WOA proposal, if that's possible, and then to offer it to the creditors and the other parties involved on behalf of the debtor. That restructuring expert should also be a totally independent party. As mentioned, it's not necessary to have a restructuring expert appointed, but as the debtor himself can also offer a WOA proposal to its creditors. But if it is appointed or being offered by an independent party, it may have a better rate of success, and that needs to be determined on a case-by-case basis.
The WOA also offers various measures to enable a company to continue its normal business activities during the WOA procedure. You may imagine that if it becomes known that a company prepares a WOA scheme, suppliers may suspend deliveries or reclaim any goods delivered earlier on the basis of a retention of title agreed upon. Such actions could cause the company to go bankrupt, which the WOA tries to prevent. For that reason, various measures to protect the business operations are possible. For instance, a cooling off period can be set by the court so that the creditors cannot claim their goods delivered under retention of title, and, for example, holders of security rights cannot execute their securities. Creditors or suppliers also cannot terminate current contracts by invoking a contract provision that says that if you offer an agreement to the creditor may immediately cease the service. Such clauses are rendered inoperative with the WOA. Financiers who finance the agreement with new money can be protected from possible Pollyanna risk. This is the risk that should the company nevertheless go bankrupt after the WOA being implemented and financed, a liquidator will try to annul the financing and the security provided and or settlement made. The court may be asked to protect the rescue transaction from these risks. By these measures, it is possible that the debtor continues business operations during the WOA procedure. A specific feature under the WOA is the possibility to propose amendment of an agreement the debtor has with the supplier or landlord. For instance, if a retailer is in financial difficulties and one of the reasons is the high rent being due, the retailer can request its landlord to agree on a new lower rent under the WOA. If the landlord does not agree, the retailer can terminate the lease agreement with a maximum of 3 months' notice. The retailer remains liable for any damages claims of the landlord due to the early termination, but such claims can also be part of the restructuring plan. This not only applies for rental agreements, but for all agreements, with the exception of employment agreements. Rights of employees cannot be amended by the means of the WOA. With this feature, a debtor can free itself from loss-making agreements as a part of the wider restructuring plan.
Well, we've come to the end of our presentation for this webinar. Should you have any questions, please do not hesitate to raise them or to contact us afterwards. Thank you for listening.
Perfect. Mooi.